This session will be, the first part of it will be a sort of a repeat of the beginning of the last session, and then we'll pick up some of the more detailed information relative to petition report and that kind of thing. A couple of things I wanted to mention. In your packets, you would have had the basic instructions, which I referenced. If you hadn't noted those, I have some extra copies of that. Also, I'm going to have Stephanie hand out an additional handout that was not in your packets. The second one in your packets was the multidisciplinary assessment tool to help you think through guardianship. And then I just, maybe you can hand this out too, is at the guardianship table we have a couple of things for your information at different points on that. One is duties and responsibilities. It's just a front and back document that you can pick up. And then the other one is frequently asked questions. And you can, it just sort of has the most frequently asked questions about guardianship. What is a guardian? What is a conservator? What can they do? What can they not do? So you can pick that information up at our table. So this session is what to expect. And in order to get to what you can expect, I'm going to just give you some background information. I'm Jean Cron, and I'm the director of the Kansas Guardianship Program. What we do is recruit and train Kansas citizens in your community who are willing to step forward and be the guardian or conservator for referrals that come to us through Adult Protective Services. So there would have been abuse, neglect, or exploitation of some kind. And we work to match a volunteer with the person for whom we have a referral. We do that throughout the state of Kansas. We work at any given time with about 1,300 people who have a guardian or conservator, and we have about just under 800 volunteers who do this. Not all guardianships in Kansas are under the guardianship program. Again, as I said, these are individuals who are without a family, who are willing or appropriate. And again, they have limited financial resources. So many of the guardianships in Kansas are that of family members, or immediate family members, or extended family members. That would be probably the majority of them. So our guardianship program is just one sliver of the guardianship picture in Kansas. The others would maybe comprise of some attorneys do this. There's some individuals who do this privately. There is a corporate guardianship program in Johnson County, and there are Johnson County people here. It's called R-Care, and it grew out of the Johnson County years ago under the ARC when it was still the Association for Retarded Citizens. But they developed this program, so they are a couple of things. One is they are a pooled trust, a special needs trust, and then they serve as guardian in some situations, and they also have a representative payee service. So that's essentially how guardianships are handled, and then there's the guardianship program. One of our agency staff is here, Sandra Jones, and Sandra kind of works in the Shawnee County, Pottawatomie County area. We have 7 field staff who work around the state. And today with me is Stephanie.
I'm Stephanie West Potter. I am the Communications and Outreach Director at the Disability Rights Center of Kansas. We provide free legal advocacy for people with disabilities. When it comes to guardianships, we don't help establish them, but we can help explore all the options and help with guardianship terminations if that is something that needs to happen. That's when our agency can step in and help with guardianship.
Right. So let's, I went over the resources, I talked about what's available, basic instructions. This is something that's required by statute, that anyone who is appointed by the court to be the guardian or conservator of somebody, whether it's through our program, whether it's a family member, whether it's an attorney, they're required to receive this, and the intent is that they read it, you become familiar with it, and at the back of it, there's an affidavit that you sign saying that you've received this and reviewed this. So if you're thinking about doing this for a person, the basic instructions is something that you'll want to have in your hands. Or if you know somebody, just take it along as kind of a refresher. The other document in your packets is the decision-making and functional assessment tool. And as I talked about this morning, for those of you who weren't here, this is a document it's an open-ended questions to help you think about the areas of a person's life that you might want to, or that you would want to assess to look for where there may be needs. Maybe in some areas the person still is able to do some things and make good decisions. Maybe there's some other areas where if the person had a stroke, maybe depending upon where the stroke was, what they were able to continue to do or not do. But it helps you look at all aspects of that person's life, from their preferred lifestyle to their medical care to things like where they might want to live, how can they function, what are they able to do, what are they not able to do. There's lots of assessments out there. This one was simply designed more with the intent of looking at abilities and where do you need supports. So that's a document that you can use. And the other one is a guide to Kansas laws. That's down at the table of the guardianship program, and you and I were just talking about that. Pick up that one as well, in addition to the basic instructions. And it basically gives a more comprehensive overview of the guardianship statutes, from definitions to duties and responsibilities, and then the process that we're going to talk about today, which is the legal process. That's also available on our website. If you can't pick it up today, you can print it off. Importance of having information, I think, is really essential. If you're working with family members, if you're working with other people who are talking and banding around guardianship, you need to understand, and that's part of what we're going to walk through today. So one of the things that's important to understand about guardianship is that there's a lot of other options to try and consider before you get to thinking about guardianship and conservatorship. And I know there are folks here who are in the school system, and I would expect that there's, in the transitional planning that should be happening, there would be some conversation at some point in time, maybe we need to look at guardianship. So one of the things that is important is to know that there's a whole lot of other things to look at and consider. So if we're looking at from the least restrictive to the most restrictive, then we're talking about what's the first thing that most of us think about? Is there somebody in the family, immediate, extended, or friends that maybe could be helpful? If that layer of support doesn't exist, then you sort of have to think about things a little bit differently. But maybe there are social services through Department for Children and Families. Maybe there's services and supports through Kansas Department for Aging and Disabilities. In the communities, there are the ADRCs, which stands for Aging and Disability Resource Center. Those are always tied in with the old area agencies on aging. And they are the resource center that they are to be your go-to for any kind of information relative to a younger person or an older person in terms of identifying where are resources that can help my person and how can we do that. Most of you here today are tied into the individual or the intellectual developmental disability communities, and so you're familiar with community developmental disability organizations, or we say in the short, a CDDO. So those are also places that the ADRC should be referring you to gather more information. If we're talking about financial things, then we're talking about if a person's receiving some form of Social Security benefit, whether that's Social Security disability insurance, whether that's SSI, Supplemental Security Income. Maybe in some situations it might be Veterans Administration payee or railroad retirement. So you can go there. If the person isn't managing their money, not paying their bills, it may be that somebody else could be named by those federal entities to handle the funds, receive and handle the funds. So as we're moving through that, we're now talking about durable power of attorney for finances and or health care. And in brackets I put there, you need to have capacity, which means that you need to understand essentially what you're asking somebody to do. If I'm going to ask Stephanie to be my power of attorney for health care decisions, I need to have some sense that I'm asking her to make decisions about my health care when I'm not able to. And what are my wishes, and how do those wishes, How do you put those in place? How do you implement them if I'm not able to? So I need to have some general understanding of that, as well as Stephanie needs to have an understanding of what my life is about and how she would make decisions for me. And you had a really good example this morning of a personal situation you had.
Yeah, I have bipolar disorder myself, and so there were times that I was not able to make smart decisions when it comes to finances or with my health. So my parents at that time had durable power of attorney for both finances and for healthcare. It saved me from going into a lot more debt than I needed to with bipolar disorder. If you don't know, people spend a lot of money, they were able to make sure that I was getting the treatment that I needed whenever I wasn't able to make that decision myself.
When you actually put that document into effect, were you in a pretty good place at that time and knew what you were asking them to do?
Yes, it was that, there are a lot of ups and downs when it comes to mental illness, and it was at a time where I knew this can happen again at any time, so that was when I made the decision.
Which speaks to that she knew what she was asking them to do, and when it would kick in, when maybe she wasn't in as good a place. So that's important, and we're going to talk about capacity and informed consent in just a moment. As you continue, the Kansas statutes make a provision for voluntary conservatorship, which would mean that if we're taking Jean as a situation, maybe I wasn't handling my bills particularly well, I was having trouble keeping up with all the Social Security information, maybe some pension information. It was so confusing with all the stuff that kept coming in. And on top of it all, I had just had some real recent life stressors and I just wasn't handling things at all. But I knew I wasn't handling them well, and I wanted to have oversight in that. And because my finances were complicated or involved because there were multiple sources of income, there were maybe I had property, whatever, I can say I would like someone to do that for me. It does not require that it shows I have an impairment, not able to do that. So it's a court appointment, puts in place Stephanie to do that. She is bonded to protect if something went amiss and she mishandled my funny money, sorry about that, that we would then be able to have those funds protected. If she took off, the bond would be there to protect them. And then there's an annual report to the court of what she did with my money, what amount came in, how did she expend it.
Who pays for that?
In that case, it would probably come from her resources to put that in place. To initiate the legal procedure.
The volunteer has to pay for that?
The person whose funds are being protected. So let's say I was the person who wasn't doing well, and I had funds, it would come out of my resources. Yeah. And since you're here today to learn more about supported decision making, as you've learned, this is both a standalone and there are options if you do have a guardian. We have full guardianship and conservatorship, guardian of the person, conservator of the finances, and then you can also have a guardianship plan that may limit some of the decisions that a guardian would make and put in place that the person themselves could do that. So we'll talk about that in a little bit. Informed consent is something I need you to understand. One of the things that I think we're all aware of is that there's a tremendous amount of misinformation out there. There's, someone will say, well, this is what a guardian does because that's their context. That was their interpretation. What I'm here today to do is to try to clarify, what does the statute say? What does it speak to? What was the intent behind when they framed something a particular way? And what was the thinking behind that? So it's important to understand, as we came partway down that continuum of intervention, up till here, this is an intervention where you can actually go to, it doesn't require that you go to an attorney. Sometimes it's helpful to do that if it's complicated or involved, and you want to make sure that the legal people have had a good overview of that. But it's not monitored by anyone. It's not filed any particular place. It's maybe if you did have an attorney, they would have a copy. But basically, that would be between Stephanie and me, and anybody else I would want to distribute that to. So it's clear that I've asked Stephanie to be my durable power of attorney for health. And durable usually means it kicks in and starts up at the time that I can't do that. So I'm right now, I have capacity, I know what's going on, I know Stephanie's a good person. We can draw it up today, and we may go for a period of time, several years, where nothing happens. But if I were to have an accident, to have a stroke or something significant, that's in place because she understands and knows my wishes. Yes?
As a volunteer, before we get a phone call, I would be assuming that all these interventions have been exhausted, or they wouldn't have made the decision that there's a need. Is that correct?
They should have had an idea that less restrictive things either have been tried and didn't work, or that the person's situation is so severe at that point in time that it's not an option to eliminate those. So let's take an example. Let's say that a person had a severe stroke, lost the ability to speak, really didn't understand what was going on, unable to make medical care decisions, and that everything that was all the indicators were this person was not going to be able to recover.
So before I get a phone call from wherever, from her buddy, I forgot her name.
Sandra.
Sandra, yeah. Before I get a call from Sandra, she's already ruled that out or vetted that. I don't have to double check it.
No. If you're working with the Kansas Guardianship Program and there's a referral to us, most of those should have been eliminated.
That's what I needed to know. Thank you.
Yeah. Now, if you're not working with our program, then there's a whole lot of other things that need to be vetted first, and it kind of depends on the situation and the circumstances.
Thank you.
But the intent is, that's what the intention of the statute is. Let's make sure that you're aware there's other options before we get to the most restrictive one down the road. Okay? So informed consent is the concept that it's a person's agreement to a particular set of course of action based on full disclosure of the facts needed to make that decision. So one of the most difficult things, and we talked about this morning, but healthcare issues are complicated. You know, and it varies in terms of severity. Let's say I've had headaches and they keep reoccurring. So if I'm going to be proactive in my health care, then probably I would be looking at what's the first thing I would want to start doing. Well, because theoretically I am not impaired and I'm able to make reasonable decisions, I'm going to go to an optometrist or an ophthalmologist and check my eyes out. And then if they see something, they go, wait a minute, there's something else going on here. We think you need to see your medical doctor because you may be dealing with something else. I then am taking in that information. Hopefully I'm asking more questions. Well, what are we dealing with? And they're saying, we don't know. That's why we think you need to make sure you follow up with a medical doctor. So you hopefully then take that next step to have that appointment to find out, hey, I've had these headaches. I've eliminated the fact that it's not my eyes. I don't need glasses, or my glasses are fine, or whatever. And then the next part of that is, so what do you do next? The doctor's probably going to say, I think we need to do some additional tests. We need to do some blood workup. We need to, you know, we're going to check out, do you have allergies? Because that's obviously a big thing that a lot of people deal with this time of year in particular. And so in the course of this decision making, I'm getting information from the doctor. And the purpose and intent of that is that hopefully I will follow through for my own self-care, to be my own self-advocate. So that's part of what kinds of decisions do I make as all of this starts to come together. So when we look at capacity, we're looking at what the person's ability to take in that information. And then what do you do with it once you get it? And then what decisions do you make? You know, did I buy step by? Didn't go past, I didn't go to the doctor. Maybe I made an intentional decision. Maybe I just was lazy. Maybe I thought they would go away. I mean, there's all kinds of reasons, but it's not because I have capacity, it's because I made a poor choice. So we look at what are the indicators of capacity, ability to manage my affairs, capable of rational understanding. Yeah. Those who work with me some days know that sometimes it's not very rational, but nonetheless, I'm there. Understanding and appreciating the nature and consequences of the decision. So that's taking the information from the doctors, asking questions. What does this mean? If I go to the medical doctor and the medical doctor sent me for information or tests, I come back and the results of those tests say, we are finding a tumor. And so now we need to do some additional testing, or this is what we found, and this is the way you can address this. Got a whole lot of other questions and things that I need to be looking at to understand the consequences, the nature of what's going on. So how is that information presented? Many times going to medical appointments, you get a lot of medical jargon. There's terminology that is familiar to them that may not be familiar to you. So how is that communicated? You need to be able to say, I don't understand what this word means. And you need to say it in a way, or tell me in a way that's understandable. Are they giving you all the information? Sometimes doctor's appointments are happening so quickly, it's hard to get all your questions in, or even to know what questions you should be asking. And that's where having a personal advocate with you to go along, to be another set of ears. We talked about the example this morning of cancer. And for many people, if that's your first time you hear that, most of the time you're going to check out because you're doing your mental scan about what that may mean. And you're not hearing the rest of what's going on. So understanding that, and you may have to come back for another appointment to get all the information that you need. And the other part about it is voluntariness. Is the person, am I free to make my choices? Is there some pressure valve? Is there some force? Is there possibly somebody trying to coerce me into making a particular kind of decision? And at that point, there's lots of factors. Sometimes, let's say I have a lot of money. Let's say that, in fact, I've been giving my family members a lot of money as Christmas gifts, as birthday gifts, and that might change. And all of a sudden, I'm getting pressure from them saying, hey, you need to do this, or, we're going to be cut off. Our little trust fund's going to be gone. And so, are you able to make your decisions without those pressure points? So those are the components for informative decisions. What's my ability to do taking the information? How is it presented to me? And can I make a decision without being coerced? I'm going to come full circle to that in a minute. It's a couple of definitions. Statutorily, the ward is the name of the terminology that the courts use when a guardian has been appointed. So somebody who needs somebody to help them with their decisions is the ward. The guardian is the decision maker. Kansas, you separate finances from a guardianship. Conservatee is the one appointed by the court to serve, and the conservator is the one, it's the other way around. The conservatee is the one whose funds are managed. The conservator is the one who does that. I also added to the definition representative payee because I think it's important to know that there's a distinction. This terminology is what's used by Social Security and some derivation of that with Railroad Retirement, Veterans Administration, but those federal income benefit sources use that terminology, that if I was not able and I was not managing my funds, somebody else could be named by those federal entities to do that on my behalf. It's not the same thing as a conservator. If you're appointed as a conservator in Kansas and the individual receives Social Security, VA, and retirement, you must go to each of those entities to make application to receive those funds. And those funds you are accountable for. So when we talk about what does the court look at in terms of definitions, and this is almost the end of the review, is they have to look at a statutory definition. So the terminology that's used is, and let me stop here for a second. This guardianship statute deals with situations where you may have minor children, where you may have to look at a guardianship because the natural parent is not able to do so. And it also deals with, when we look at this definition, any type of situation where it may be a person with intellectual developmental disabilities, severe chronic mental health, it could be aging related with dementia, it could be a traumatic brain injury, it could be any combination of things whereby, without the label of what your diagnosis is, that they look at the circumstances. They look at how does the person, so we talk about it as an adult with an impairment in need of a guardian or a conservator or both. So I'm now talking about persons who are 18 years of age. Kansas, when you turn 18, you're considered to be the age of majority, and you are your own decision maker. You're no longer a minor child where you have that parental or minor child influence. You now are considered a magical adult, and you can make all your decisions wise and appropriate. So if their situation is such that you were to go to court, at this point is when this definition is given consideration. So it means a person who's 18 years of age or older, whose ability to receive information, evaluate the relevant information, and to communicate decisions, or both, even with the use of assistive devices. So if you have a hearing issue or whatever, that those all help you make the decision by giving you the information in the format in which you need it and understand it, is such that the person's impaired, that they are unable to take care of their physical health, safety, welfare, and in the case of finances. So, what does this sound like? Ability to receive, evaluate, and communicate decisions. Informed consent. That's what we talked about earlier. Conflict of interest is addressed in the statute to look at if the person who's going to be named as the guardian for another person, is there a potential between the two of them that there's a conflict by positioning? Let's say that I'm the personal care attendant for Stephanie, and I'm getting paid to do that. And it would not be appropriate in 99.9% of situations for one or the other to be the guardian of each other. Whatever the analogy was that I gave in the beginning. So the point being is that I'm getting paid, and I'm also the decision maker. Can you see where there might be a conflict? And so the statute has now added this piece to say we need to look at what the relationship is. One of the things for anybody who's been involved with any of the waivers, the home and community-based waivers, that KDAS a number of years ago came out and said clearly, if you are the paid caregiver, even if you're the parent of your adult child or adult person, and you're paid, that they're saying that's a conflict of interest, and here's the steps that you need to go through to remediate that. So I'm not here today to interpret KDAD's rules and regs, but you need to be aware of that. And generally, it's my understanding that the managed care company, care coordinators, are the responsible entity for keeping that monitored. But anyways, to know that that's something that the court should take into consideration. Okay, so this is where we're hitting new material from what we did this morning. So in order for, we've talked about that assessment tool. We've eliminated the fact that there are options, because I'm going to give you the scenario. So this is a scenario with an elderly person who had early stages of dementia, but in her case, she had a severe stroke. She did not have any power of attorney. She didn't have anybody who was really assisting her, and now she's in the hospital and or in long-term care or something where and they're saying she can't be making decisions because she's not understanding what we're telling her. She can hear the words, but it doesn't mean anything to her based on the damage from the stroke. And so if she's not able to understand it, comprehend it, then she's not going to be able to communicate that decision. So if we're going to be considering a guardianship in this particular case, then how does that happen? Generally, again, most of the time in Kansas, to initiate a guardianship process, you're going to be working with an attorney. And once you've made that connection with the attorney, it's going to be in the directorship or the driver's seat and moving that along. That said, what is important is that you understand and know what are the pieces to putting a guardianship in place. So in the Guide to Kansas Laws that I don't have a copy of with me, but they're downstairs or online on our website, there's a section in there that said from petition to appointment. So the first thing, the way that you can get to the court's attention is you have to have a petition. You've got to be able to say to the court in Saline County, in the matter of this issue, we believe that Sarah Jones is in need of a guardian. So the petition has to carry certain kinds of information. It has to say who is the person, where do they live, what is their estate, who are other interested parties who might want to know about this, and other related pieces of information. Have they been in the system before? Are they a younger child, or maybe they were a child in need of care? Obviously, this example doesn't apply there. But remember, this process is for anybody who's 18 years of age and over. So, you have that petition, and you file it with the court, and you say that Sarah Jones needs a guardian. And these are the reasons. Oh, we also think she needs a conservator. And these are the reasons why. Because she has multiple sources of income. She owns 3 pieces of property. And she has a vacation home in Florida. So her estate is fairly involved. Once the court gets that, so we're asking for both a guardian of the person and conservator of the estate. You file that petition with the court, and the statute says, okay, we've got some things that have to happen. Those are called mandatory orders. So, and the attorney should know what those are. So they say, we need to know, you need to set a date and a time for the hearing, for the guardianship hearing, or trial. They changed the terminology of trial. Another thing that in Kansas law says, you also get an attorney appointed to represent you throughout this process. So for Sarah Jones, somebody will be appointed to represent her in case maybe whoever the petitioner was trying to do something nefarious and really not all the information was being presented to the court. So that attorney is assigned to Sarah, and that attorney is supposed to meet with her, to talk with her, and to get a sense of what might her wishes be. Well, the other part of the scenario is maybe Sarah wasn't as confused. Maybe she just had some speech issues, but cognitively was aware, and nobody took the time to realize and work with her on the communication piece. So the court-appointed attorney, one would hope, would do his or her job to determine what her wishes were. And if Sarah was sitting there the whole time saying no, 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 that may tell you something. You should be doing some more digging. Maybe that person says, hey, we need to do a more in-depth evaluation. We don't have enough information to take to the court. So that's that examination and evaluation piece. When you file a petition, you can include some documentation, but sometimes that's not very thorough. So the court appointed, again, if that attorney is doing the job that needs to be done, they should be saying, I want to have an independent evaluation that looks at this situation and looks at Sarah's situation. So those are things that are sort of things that are set in motion to make sure that you're protecting that person's rights. The other thing is that you have to send notice. You have to tell the people who might be interested that this is going on. So the statute speaks to, siblings, parents, grandchildren, and you're kind of looking for the people who are in the immediate concentric circle of that individual. And so we've had all those pieces have gone into place. The attorneys visited with Sarah, and now we've got the hearing. And in the course of discovery, the court-appointed attorney finds that we haven't done a valuable assessment. We're in trouble. This woman really only has speech issues, cognitively really not so much, and this guardianship isn't necessary. So when they have the trial, that attorney should be presenting the information about why this isn't needed, and can call for testimony. It may be in the form of written, and then it's up to the petitioning attorney to show the court why this is needed, okay? So it's in that setting, and you can have a contested hearing on a couple of levels. Contested means somebody's not agreeing with what the petition says. And the petition, when it says going forward, they're going to have Stephanie be the guardian. So there's two levels. One is to say the court-appointed attorney should be bringing evidence that says, Sarah doesn't need a guardian. And then secondly, they're saying, we don't think Jennifer's the right person. Let's say that Jennifer was my granddaughter, and my granddaughter had been exploiting me. Not the right candidate. She was the one who goes to court and says, hey, we need to get grandma's guardianship. But she's been on wings, and she's been writing checks and forging my signature. She's been busy. And so she may, in this discovery, that may have come out. And so it may be that maybe the guardianship is needed, but maybe it's not the right candidate. Okay? So those are the kinds of dynamics that can play out in a court hearing, and again, should be a part of the process to protect my rights. And sometimes that due diligence is not always done, but I'm telling you, that's your framework or your basis in your statute. The other thing is that we have 105 counties in Kansas. And so you have large urban courts, you have small rural courts. The rural courts will handle every type of case. In Johnson County, Wyandotte County, and Shawnee County, you have a judge who does predominantly guardianship issues or care and treatment, which is the ability to get involuntary psychiatric treatment for somebody. So it really varies with the court. Each judge will do things differently. Sometimes they'll do the hearing in a courtroom in Shawnee County. There's a courtroom that's set up and the judge is there and you file in as your case, comes up on the docket. In other counties, it may be, if it's an uncontested thing, it may be simply handled in the court chambers. But that is going to be peculiar to the county and the court and the judge. After the hearing, and all that information has been presented, or in some cases it's clear that the person really does need a guardian, and it's really appropriate that Stephanie is the person to do that, the court makes its finding, okay? And it agrees with all of these things that have been stipulated and says, this is what needs to happen at this point in time in this person's life. They then make a determination or an adjudication that Sarah Jones is in need of a guardian and a conservator, that Stephanie is the appropriate, and appoints her as the guardian and conservator. So that's the court's finding, its rulings, and you'll find that information if you're at all looking at documentations, if you're a provider. The order, so after this hearing, this whole order gets spelled out, and it reiterates what the court's findings actually were, okay? And after that, there's a couple of things that have to happen. One is that she needs to sign an oath and a bond, or an oath that says she's going to do what she said she would do in response to what the statute put forward, okay? If you're a conservator in Kansas, you are, and Hamilton needs money, then there's a protection built in there, and that's a bond. And that would require that in my large estate that I gave in that example, that she would need to find an insurance company that would set, that she would be able to purchase a bond to protect my funds. That's a part of doing business. And so those are protections that are built in. So let's say that bond is in place, and let's say Jennifer was not doing what she was supposed to do, and she was exploiting me. And somebody finally gets that, figures it out, then there's a way to come back, and if she doesn't put money forward to replace those funds, you can go after the bond. Okay? Does that make sense? So it's a protection that's there, and the cost for that comes from my estate. Those are all costs of doing business.
Can anyone just go out and get a bond?
There's not a reason to get a bond unless you are court appointed
Right.
as a conservator.
But, like, what are the qualifications for getting a bond that people
Well,
should know about?
Oh, good question, and that's not my forte, Rachel, but it's a good question. But clearly, they set the bond, let's say, they set the bond based on several things in my estate. So let's say the bond needs to be set at $2 million. So obviously, the bonding company is going to want to have some information about her, and essentially, in my terminology, sort of reliability, and to see whether she would be a good risk.
Yeah.
And it is hard to get those bonds.
They run your credit, that's all I was trying to say.
And good, thank you. Right, right. And it again depends on whether, particularly the size of the estate. We talked about those basic instructions that you all have. At the back of that document, there's an affidavit that you sign and say, yes, I received these, I read them, I memorized them, I know them. Okay, maybe not so much the latter, but that you've received it. That gets signed off, and that becomes a part of the court record as well, just to assure that that due diligence is done. All of those pieces are now in place. The final legal document that puts in place Stephanie as the guardian and conservator for Sarah Jones is what's called letters of appointment. And usually in the legal documents, you'll see at the top of the thing in the district court of Shawnee County. And then on the side here, it's saying matter of the guardianship and conservator of Sarah Jones. Over here is the case number. And the next thing is the caption or the title of the document. In this case, should read letters of guardianship and conservatorship. The date of those, full power and authority, or if there's any limitations are put in there. So that's from your petition to appointment. What has to happen? The amount of time that it can take, statutorily, it says not less than 7 days and not more than 21 days to get this hearing. However, as you all know, there's always a however, and let's say they weren't getting all their information together. They learned that there were some more issues. There were some out-of-town family members that suddenly surfaced and said, whoa, what's going on? We're going to get an attorney. We want to be at that hearing. You can get a continuance of that court date. And that can sometimes drag out. Essentially in a contested hearing, it can go on for quite a long period of time. There can be multiple attorneys. There can be the petitioning attorney. There can be the attorney to represent Sarah Jones. There can be an attorney to represent Stephanie and any other family members. And so you can have, in a contested case, a really complex scene that the court is going to have to work through. In a non-contested case where we're saying it's clear that this dementia is severe, the stroke exacerbated it, Stephanie's absolutely the best person to be that guardian conservator, it's not going to be a complicated legal process. So we've talked about that. This is the petition asking for the need for the guardianship. Here's a little bit more information about what gets included in that, and I think I reviewed all of that. And it includes names and addresses of people who would testify. In some courts, if it's a contested matter on the capacity of the person, it may be that they will want a medical doctor, psychiatrist, psychiatric person providing testimony, and that can be either in person or in some cases they will Skype the person in. So again, it kind of varies. If the information that was submitted to the court with the petition, or that the court-appointed attorney had added to the file, that's not adequate. Many times they will want to have somebody testify. This was the information I talked about. I'd forgotten I had all this on there. What gets included in the petition. And again, in this situation, they should have disclosed if there had been any conflict of interest. And let's say that I had been paying Stephanie to handle my affairs before the guardianship. You might want to make that issue clear in terms of it is appropriate for the guardian conservator to request a fee for services when for that guardianship service if there are funds available to do that. In general, you have to petition the court for approval for those funds. We talked about the mandatory orders. We talked about the exam and evaluation. Again, that happens. Sometimes it's not very detailed and involved, and it may be a doctor saying, you know, that Sarah Jones has dementia and had a stroke, and she's no longer able to make informed decisions about medical care and finances. And it may be almost as simple as that. Hopefully, it would be more detailed. Just depends on who says that's going to be adequate, and if there's something that's contested. Notices I've talked about go to those people who have some kind of interest in this. We talked about the court findings. What does the court take into consideration? The legal standard is clear and convincing evidence. Okay, that's important to know. Let's say that in the findings, the court determines that guardianship isn't necessary, that Sarah Jones is capable of doing this. They may want to add advice to say, working closely with the bank officer to protect some of these more vulnerable assets. There could be any number of things in those findings of guidance from the court, but those are verbal, but if they can dismiss it and say there's not a need for guardianship or conservatorship, and the case is closed. It's done. So those things do happen. There are times when people are not always motivated out of the best intent, and so sometimes want to potentially set up a situation that they may believe in their hearts is the best, but may not always be the case. If you are the conservator, if you handle somebody's funds, the statute requires that you complete an inventory and valuation at the time you are appointed. This shows the court what the person has relative to income, benefits, property, real property, personal property, and tangible property. And that gives the court an idea. You show the court whether there's debts, things that need to be paid off. But it's intended to give the court a picture of what does the person's estate constitute. That's to be filed within 30 days of appointment. Sometimes it's later than that, but it needs to get in there. Let's say because I have a large estate, for Sarah Jones had a large estate, and in the discovery of this, Stephanie thought she knew pretty much what the estate was. In starting to go through things, all of a sudden she finds that there's bank accounts that she didn't know about. There were investments that were known about. And she'd already filed the inventory. You simply file an amended document that says, in my discovery of marshaling the assets and the resources, I found this additional information. Or, the house found along the way that even though all the documentation said I still had the house in Florida, it in fact had been sold. So you want to get it off the inventory. Because the court's going to be monitoring those large estates. So,
I have a question.
yes.
When you're a successor guardian or conservator, I guess conservator, is that the same process? Like, is the inventory still required?
Excellent question. The different types of guardianships, I think I missed in this particular slide set, but if you are the conservator, and let's say we've gone through this initial determination, this initial adjudication, and let's say that Stephanie's moved out of state, she no longer could do this, and we wanted to have another person be named. You don't have to reprove the disability or the impairment, but you need to make an statement. You need to get an attorney. You need to petition the court and say, Stephanie no longer can do this. She's moved out of the country, and that Mr. Smith over here is an appropriate person to do this. When that person takes over, then there's another process. But as Stephanie finishes up, she needs to complete, by statute, a final accounting and a report to the court. So at the end of her time, as the appointed conservator, we know where things ended up.
What if that person dies? I mean, I'm just
these are
being really honest because it happened to me.
Let me pick up on that in just a minute.
Okay.
So the new person coming in is going to want to look at that inventory and re-verify all of that's the case. In a situation where the first guardian passed away and that final account, that information wasn't available, it really kind of depends on what the court wants to do in that situation. It may be that it's the responsibility of the new incoming person to sort of start afresh. Now, hopefully, there have been some accountings for prior years.
For sure.
If that didn't happen, the new person's starting from scratch. and having to find out where are the bank accounts, where are the investments, where's the property, etc. And those things absolutely do happen. And you sort of seek the court's guidance on that. How do we want to proceed in this? 10 minutes. A couple more things, and then I think we're done, and we can do questions. Costs that are involved. Your payment is for your petitioning attorney. That varies a little bit with where you are in the state. Sometimes, if it's not a contested case, everything is going to be smooth, and you have the right attorney, it could be under $1,000. Generally, it's kind of in the $1,500 range on the low end, and in Johnson County, and I'm guessing in Sedgwick County as well, you can be upwards to $3,000 for a basic guardianship. It's sort of another reason to think through, are there other options that are appropriate and viable that maybe aren't that involved and that costly. There's court-appointed attorney, usually there's a fee with that. If there's resources in the estate, it would be assessed against Sarah Jones's estate in the example that I gave. If there were no funds, for example, it may be assessed against the county. It can vary. There's a couple of other ways that they deal with that. There's a filing fee to get this petition paperwork into court. I think it's in about the neighborhood of $85 ballpark. It's under 100 right now. And then depending upon where the evaluation and the assessment was done, it's possible that if insurance didn't cover that or Medicaid didn't cover that, it may be that it would be assessed against the person. It depends on who did the evaluation and where. So as you can see, this is not an inexpensive process. It can be an appropriate and legitimate process, but it's not uninvolved. So if you're seeking an attorney, and one of the questions that was asked to me during the break after the first session, what if they don't have any funds? Maybe this is a family situation and their funds have to go for food, lodging, taking care of the kids, and they have an adult child or a child who's turning 18. How do you proceed? Again, that's a tough one. Sometimes in some communities, Kansas Legal Services may be available. In other situations, there may be, maybe the local Community Developmental Disability Organization has some attorneys that they've been working with. Many of them have attorneys on their boards of directors that maybe are doing this at a reduced cost. And sometimes you're looking for somebody in the community who will just do the right thing for little or no cost, but it's not an inexpensive process. Stephanie talked about this morning, and I think it's something you need to be aware of. One of the ways that you can individualize a guardianship, and I talked about this morning, is that there's kind of a framework that the statute has to create a guardianship, and it talks about, you know, you need to get to know the person, you need to make decisions as are needed by the person. Not every decision is one that's a legal decision. Many of those are personal and human rights kinds of decisions. Sandra and I have talked about this at length. These are conversations that we have in the office because we get calls saying, you know, my guardian won't let me do such and such. They won't let me wear a Kansas City Chiefs jacket. They won't, I mean, sometimes it's that, almost that uncomplicated and almost silly. We laughed about one this morning. Coloring your hair. My person wants to dye their hair green. And my guardian won't let me do that. I want to have a tattoo. My guardian won't let me do that. Those are not legal decisions, unless the decision was for me to go to a backstreet shop where I'm running some pretty serious risk of having somebody who doesn't know what they're doing. I'm not getting a clean tattoo. So then what is the guardian's responsibility in such a case? I would say then find a place that does it legitimately, and are there funds to do it with? Because it really comes down to that in a lot of situations. You may have a person who says, lots of things I would choose to do. I don't have the resources to do that. So I can have a choice, but the consequence is I can't have it because I don't have the funds to do it. So again, looking at what the issues are. Those personal care kinds of decisions really, that doesn't mean you wouldn't necessarily talk about them with your guardian. We laughed about one this morning. You know, the whole business of personal self-care and people who don't want to take a shower. What are the reasons for that? What are the reasons for poor self-care? What can we do to help with that? There's lots of ways to look at that, but I can't make Stephanie take a shower if she doesn't want to. Does that mean we stop working on trying to do that? Because that's an important, because she's not going to have quite as many friends if she doesn't. But there's lots of things that we keep working on. So I digress from the conservator guardianship plans, but sometimes there's situations where we want to make the court aware that we might be putting some, the person may be having some abilities to do some things, and you want to make the court aware that, Stephanie, can manage, even though I'm the conservator, she can manage her Social Security benefit, or she can manage her employment work, and I'll manage the Social Security. Sometimes when there's some really serious behavioral health challenges, you want to just make the court aware, because again, there's a lot of misinformation. People believe that if you get a guardian, you can make a person behave in a certain way. And that's simply not the real world, nor is that the role of a guardian. What can a guardian do? They can sign consents for behavioral health care. Can't force it on them. Can you force medications? Other than in some isolated situations in the state hospitals where there's statutory authority that allows for that, you can't. So that means we have to become creative. We have to work with the individual. I think the diets is probably one of the most complex things. When the doctor says, you need to be on a diabetic diet because your sugar numbers are out of sight, and the person says, I want to eat what I want. So how do we tackle those kinds of healthcare issues that are significant? Because if the person goes into a diabetic coma and somebody's not present, they may not survive. But can we force diet? I don't think we can. But I think it's incumbent upon all of us to be creative in what we're doing to try to work with some of those types of situations.
Yeah, in a nursing home, a doctor could force the diet, right? They could say they need to be on low salt.
The doctor can put that in the doctor's order, and certainly that's a part of what a guardian's going to be working with to try and implement a diet that's going to be better for that person's health care.
And then what if the person says, that doctor is starving to death, I want such and such?
They can say that, and what typically happens is that they can also provide that food, like that low salt diet to the person. They can choose to eat it or not to eat it. If they go anywhere and buy snacks, they can eat that or not eat that. And that may be where you start seeing that people aren't following that diet. Can you make them not do it? Can you restrict their movements so that they don't go anywhere and get their snacks? Well, no, you really can't. What you can do is enter into conversation with folks and say, this is really not good for you. We're really concerned about you, and hope that that has an impact and continue that conversation. But can you really make people do it? And would you really want to have an argument with them about it all the time?
Yep.
But the nurse or somebody isn't going to.
Well, I think the real world is that there's things that Jean Cron should not be eating. The cinnamon roll she had this morning, the dinner roll that she had with lunch because she didn't need the extra carbs. But I made that decision, even though I shouldn't be eating it. So I think what we have to do is we're trying to strike and find some kind of balance in all of this. And it's a journey. It's working toward trying to. And some of it is, because people are willful and going to do their own thing. In other cases, they may be confused. But you continue to try to address the issue by being creative, but to not force people because we can't do that.
Yeah, because that's not our place.
Yeah, exactly.
And that's part of like what we were hearing earlier today, is what was the framework. We look and help guide them to make the right decisions.
Yeah.
Still as guardians, we're going to, or conservative, all we can do is just help support that person, but they're able to make their own decisions.
You can provide the consents. You can work toward the decisions. But there's a lot of things that we simply cannot force because that's not how it's structured. The back.
In nursing homes, it's called culture change. You are allowed to eat whatever you're going to eat. You cannot they want hot dogs for every meal, they can have them.
Oh, really?
It's called culture change.
Yeah, there's more at home, that they aren't trying to move away from that more institutionalized model where we're going to say this is what you have to do. But it does mean that it's complicated. And it's not any less complicated than it is in all of our lives. And if you have a household of children and people in your household who have different diets, and how are you going to do that? How are you going to keep people healthy? It's complicated. I just got a signal a couple of minutes ago that
Oh, yeah.
3, and so thank you so much. We'll be around if you have questions.